You're a professor.
Well, I do some teaching now, yes, at college, yes.
Okay.
Well, it's not a teacher, it's a professor.
No, you're right, yeah.
Yeah.
She doesn't like that.
Okay.
Yeah.
Ms. Garces, how are you?
Great, how are you?
Great, it is great to see you.
Thank you so much for having me.
Well, we're so glad you're able to come in person. And I know you, if you were still here, Senator Persick would give you a special welcome. Well, Senator Persick used to sit here, yeah, yes. But if Senator Weeks were here, I'm sure he would give you a special welcome as well. We're grateful that Ms. Garces is here to talk about the Human Rights Commission and give us an overview of discrimination and harassment. And I know you have provided us with a handout, and I apologize. You did reach out to me earlier to come in, and I'm sorry I didn't act on it faster. So we're glad you're here now.
Oh, thank you. Thank you so much for having me.
And just so you know, Senator Weeks will be coming in. We just had our sexual harassment sort of policy update, and he's running a little bit. So.
So yeah, for the record, my name is Amanda Garces. I am the Director of Policy, Education, and Outreach for the Vermont Human Rights Commission. And I really wanted to give you an overview of how our commission works and some of the things that we're working on. We think it's really important to just kind of have, when you're thinking about discrimination and thinking about public schools, just kind of our role in that. So I gave you this really short presentation, more for me to give me in line.
We got it right in front of us.
And so the commission has been around for about 30 years, and we have been the chosen entity to enforce the discrimination laws, and we are an independent commission. So I want to walk you through what we do. So we enforce the following discrimination law, the Fair Employment Practices Act, and this focuses more on state employees. So if an employee is retaliated against because they took workers' compensation or parental leave, or they want a flexible working condition, or they're just being discriminated against, that is in our jurisdiction. If they work for a private employer, then they go to the Attorney General's office. Our next one is the Public Accommodations Act, and that is really broad, which is great for Vermont. We enjoy a very broad definition of public accommodations.
This one right here. Okay.
And yes, the first page. And our courts have held that places of public accommodations also include governmental entities. In our statutes say the places of public accommodations includes any school that brings in cases, that also brings cases from inmates, police brutality. So it's really broad. And we also see cases against hospitals or clinics and so forth. So that's our jurisdiction.
Could you say a little bit more about that while we're on it? So everyone has to follow, all businesses, government, schools, everyone, public, independent, has to follow the Public Accommodations Act?
Yes,
No.
anybody, so it's with anybody that has, is providing a service to people
In the state of
in the
Vermont?
state of Vermont.
Okay.
So that's our state statute.
And so give us some examples of what that would include.
So that includes an inmate who is not getting services at a correctional facility. We had a case of someone who was not provided hearing aid. We have cases where in restaurants, if they're not being served because they're Black or Latino, that is a place of public accommodation. So anything that's providing a service to the people of Vermont.
So as we're the education committee, I can see, of course, some of those things could come up with faculty and staff at any school, but how does it relate to, is it related all to educational opportunities or offerings? For example, if your child, well, does it in any way?
So harassment in
Yep.
school is our jurisdiction,
Okay.
and so if any child is being harassed because of a protected category, that
Okay.
goes into there. I think for teachers who are, that they go to the Attorney General's office because those are considered private employers.
Okay,
So that is not our jurisdiction. Students with disabilities also are not our jurisdiction within that piece, like if it was like an IEP related. And so let's say that you have a student that is not allowed to join a student group.
Yeah.
And like the school's not providing that support, then that, they could come to us. We've had cases where, and Rachel had more cases than remember I'm the education outreach now, but so in terms of schools, we have a lot of harassment cases that come through,
you do,
or
okay.
yeah, and we've seen an increase of those. That's
So with the IEP, for example, if a school doesn't follow let's say I had a child in third grade, they had an individualized education plan, the school didn't follow it, for example. Do I as parent have then the ability, is that what?
no.
Okay.
But I think that no, the IEPs go through like the Agency of Education.
Okay.
The whole special education plan was
Yeah,
through the
yeah.
agency. But if they're not providing some IEP because they're Black,
Thank you.
because it
Okay,
is related
helpful.
to its protected category,
Okay,
and that is considered discrimination, that is a little different, but not following the IEP or not doing like the structural pieces of the special education law, so.
Senator Bloom.
You said, I may have misunderstood what you said, but you said something about hearing aids.
Yes,
Can you say that again?
yes. So we had a case in one of the prisons where an inmate was not getting their hearing aids. That is based on disability, so that place is public accommodation, not providing that service, that support for that. So that was one of the cases that we have.
Okay.
In your report, you'll see that one of the losses.
Okay. Thank you.
And then the third piece is the Fair Housing Act, and that's kind of self-explanatory. Anybody that is being discriminated against because of protected character around housing. This could include even harassment, neighbor to neighbor. And we have some cases on that. So that's kind of like our statute. We also have some of gender-neutral bathrooms that we oversee, which passed in Act 127. And here's a list of all kind of our protected categories and how they are related to each of our three statutes. So you could see, raises in housing, public relations,
Sure.
What is the law on gender neutral bathroom? Because I thought I understood it, but I go around different places, restaurants, and they all have a different. I think there was a symbol that was supposed to be used.
Yeah.
by everybody, right?
So they're supposed to have single-use restaurants to have the gender neutral
Okay.
usage. So if they have one single stool, they have that for.
Okay, so that's actually good for it. Some places only have one bathroom. They used to have a male and female bathroom. So now they only, okay.
And so they have to have the sign. So people can send us in order to say, hey, I went to this restaurant and they don't have it. And then we'll send a letter to them and try to get them to do it.
Okay.
So the way that our enforcement works is people put a complaint and the agency will receive the complaint. We will open up an investigation, so that goes to our attorneys. We have 6 attorneys, 6 employees. We have 6 staff, our executive director, their assistant, myself, and then 3 staff attorneys. So they begin an investigation. Through all this time, they can start negotiation proceedings for settlement to try to settle the case at all of these stages. They issue a report that will say we find reasonable grounds or not. And that report is given to the commission that meets once a year. There's 6 commissioners that are appointed by the governor, and they look at these cases on a monthly basis. And so again, like through all this time, there's trying to have settlement agreements. And then once they get up to the commission, if they found reasonable grounds, that they can, it goes back to our executive directors for either try to settle the case within, I forget how many days, and then if not, they go through litigation. So we have some cases in litigation, and you can see in the report a lot of that. So in terms of education, like we also are part of how we claim investigation. We also do a lot of proactive work. We sit on a bunch of workforces. I chair the Fair and Impartial Policing Committee. I chair the Act One working group, and we have some colleagues that are in the Criminal Justice Council. And then I also sit in the Citizen Bullying and Harassment Council. And so a lot of the work that we are doing is proactive, education and outreach. We do inclusive bias trainings, bias-centered intervention, and then trying to push, our culture shifts in our education system as well. So there are a few things that you can do. And in terms of education that we think is really important is to kind of look at our bullying harassment cases. Like I said, those harassment cases have increased. It could be, part of because of the work that we're doing around Act One and moving that work, but also because of the outreach and education that we do with a lot of our grassroots organizations that are in Vermont around education. And we have some really specific suggestions for the agents of education to kind of hire someone that can lead a bullying harassment campaign that can support cultural shifts in our schools, including independent schools.
Do you have those recommendations?
No,
No,
I
okay.
don't.
Okay.
But I can send it.
That'd
to
be
you.
great, yeah.
Yeah. I think that one of the things that we also see is that bullying, for example, doesn't have a way, so harassment cases can come to us, but bullying cases have a clear channel outside of the school district. So having a channel for students who are being bullied that is independent as well will be really important. And then there's just a need to have more conversations about how that cultural shift.
But you don't deal with the bullying now?
Hmm?
You said they're gonna start channeling bullying through you too?
No,
Oh, you are?
no, that's not, we're saying that there needs to exist another
okay.
channel, but not necessarily us. It could be the agency of education have an independent channel for that. And I love that. So one of the, there's a bill in the House that is coming up right now by Representative Coach Christie, that is to change one thing in our harassment laws, which is the severe and pervasive law. So we passed the House last year, and basically is clarifying the standard around severe and pervasive. So one example is when to prove severe and pervasive in the harassment laws, you have to really have a level of severe, right? So you have to, if you are a woman and then touch your breast at your work, that is not considered severe and pervasive. If you have a coworker that's asking you over and over again, go on dates, and you're saying no, that is not considered severe and pervasive. And so we're trying to shift this to be able to allow for more people to come to our door and to give this opportunity for people who are experiencing what the courts might say that is not severe. So that goes over there, but I would love for you to think about how to support that, and we can send you more details about what that looks like.
I have a question. What would the alternative standard be compared to the severe and pervasive standard?
So that what we have right now is
Yeah.
the severe and pervasive,
Yeah.
right? And it has high bar. So for someone to come into the door, you have to just, maybe Rachel can talk more about what it looks like, because an attorney at legal aid. Rachel?
Hi, do you want me to, for the record, I'm Rachel Seelig, I'm the director of the Disability Law Project at Vermont Legal Aid. So if the question is like, what does severe and pervasive look like? I can give an example of a student with a hearing impairment who is continuously ignored by classmates or teased by classmates or called names by classmates because of their use of an assistive device for hearing. Or I can give an example of a student with a disability who's also biracial, who is sometimes teased because of their disability and sometimes because of their race and sometimes because of their gender. We would view that as severe or pervasive. Whether the Office of Civil Rights or the Human Rights Commission can conclude that really depends on the evidence available. But oftentimes it starts with words and then becomes physical. And what we often see is that the student who's being targeted finally responds, and then they are the ones who are removed from the situation rather than the students who have been targeted.
So if the severe or pervasive standard was removed, what would the alternative be?
So we had some language that passed through the House last year that would lower the standard, and I apologize, not remember, do you have the specific words that we had last year, Amanda? But essentially it would be more than kind of minimal or annoying, but it would be, so that a child doesn't have to, go through 3 or 4 or 5 or 6 incidents of being, the target of their peers before they can have their district take a look at the situation, say, yes, it's harassment, and then do the education and do the kind of, whether it's restorative practices or other kind of positive behavior interventions and supports. Our hope is that it's an educational process and the students learn. And if that still doesn't work, then move on to kind of more disciplinary consequences. But we're also working very hard to ask you to not let kids be removed from school for disciplinary reasons. And so it's all connected in our view. Yeah.
Senator Williams?
So are the incidents that you just talked about on the increase,
Yes.
increasing, or are they pretty stable?
No, they're very much increasing. Yeah. Yes. I think we've gotten 6 intakes that have to do with harassment or bullying in the last week and a half. I mean, it's that may be a little bit of an overstatement, but it's quite frequent that families are calling us and feeling like their schools just don't have the capacity to address it because schools are overburdened.
And I think that, so the part is like that we need to really look at this as in a holistic way. The agency it's an enforcement agency and we don't represent students, right? So they usually go through
us if there's a disability.
If it's disability, sometimes it's.
That's right, I stepped out, so you're with,
I run the Disability Law Project at Vermont Legal Aid. I did put myself on the record.
no, I just,
Yeah,
no, I apologize, yes, no, I'm glad you pulled it, yes, no, I'm glad.
I'm always like.
I told her she could if she wanted.
Great, no, it's great,
So yeah, I think it's looking at this from a holistic perspective, the work that is happening around like mental health and what is needed, like it can't be alone, it has to be connected to all these things, like, well, how are we dealing with bullying and harassment? We can just pass the policy and leave it, but what is the support, the training? We are currently working with the Office of Racial Equity to come up with a training for students and families to know your rights, around know your rights, and waiting for the agency to give us an update policy on it. I think that so there is ways that the Senate can really support students right now by saying this is important to us because we know that there's an increase and many families feel hopeless. And so I can bring many here that say, I don't know what the answer is. So I'm just kind of pleading for them to let's look at this in a level. As you're having this conversation about the public dollars, that we're also looking about how we are supporting our families in our public schools as well, and independent schools that are dealing with this.
I think it's great that you're looking at it, because I think it's more prevalent than a lot of people realize. I think, you know, my daughter used to come home from crying every night because this group that she wanted to be a part of were picking on her all the time. It wasn't really one of them. And I mean, it really has a devastating effect on these students.
Yeah,
Ms. Garces, last year, we passed a bill, with Senator Ron Hinsdale and Senator Sears' bill that's no more suspensions, expulsions up to, I think, no one under, I think it was third grade or something like that.
third grade.
Yeah, or
And actually, it was age 8.
it was age 8, that's right,
Yes.
okay. Do we know do you have any sense of what's happening out there in your, you know, again, I know you're not representing students, but anything that you're hearing from your side of things?
I don't,
You want me to answer?
Yeah, please, absolutely.
So first, we have a whole proposal that we would love to talk to you about,
Great.
kind of following up on Act 35
Yeah.
and that work group. In terms of the removals of children under 8, we are still seeing it happen.
Yeah,
We are seeing families being told it's not for disciplinary purposes, but you can't bring them back because we don't have staff, or we need to set up a program for them. And we've had students out of school for months because the staffing shortage, and they're not willing to allow the child in. So we're still seeing it with children under 8. And I think we're actually seeing, because of staffing shortages, schools feeling like they have to revert back to more traditional discipline instead of positive behavior interventions and supports, reinstituting things like detention, after school detention, in-school suspensions, just separating students that have become behavior problems rather than working on meeting the needs to help them deal with those behaviors. And so some of what I think we would love to talk with you all more about are things like additional teacher training, additional funding at the agency to have an expert on safe and inclusive schools to support the districts, much better data collection on the use of restraint, seclusion, exclusionary discipline, and kind of more longitudinal and more, you know, with more of an equity-based lens to it. And so we've got a whole bunch that we'd love to come talk more about, because unfortunately, just saying, no, you can't suspend children under 8 doesn't mean children 8 and under aren't being pushed out if there's an issue. And I know from the school perspective, it's actually been a challenge because of the third grade thing. They have some 8-year-olds and some 9-year-olds. And so why are the 8-year-olds getting treated differently than the 9-year-olds?
I would welcome that, you know,
Love to
welcome it
get on the
after
schedule.
crossover, and
After-
you can
yeah.
work with Hayden. You know, we know that there is, Texas did the study, you know, school to prison pipeline. If you're
Yes.
suspended and or expelled, you know, you get behind, it's tough to get caught up, you start acting out, you drop out. I mean, I think the evidence is.
The evidence is incredibly clear.
Yeah,
So the question is, how can we help our schools meet the need
absolutely.
rather than excluding students?
so yes,
You said Act 68? Is that
Act 35.
35?
and they did a report.
They did do a report, and your counterparts on the House did hear from some of the people who worked on the report earlier. I think maybe earlier this month. And I think those same folks would be happy to come in and talk about the report and, you know, talk about what we think are good next steps. So.
Yeah, and it would also be great to understand whether or not, and this is a little bit of your work, but back to the bullying piece, how hard is it for a kid to get out of a school? I know Representative Sevilla has a bill that could allow you, I think, to, there are 5 elementary schools in that district, bam, put you in another one, you know, make a little, be able to, without a lot of sort of formal action, given the severity that bullying can.
I think there are risks of disparate treatment with those, especially for students with disabilities.
Yeah.
Having another school have the choice to take them or not take them because of their level of need. And I can tell you from my work, The only situation where I was able to move a high school student from one public school to another public school, not in the same district, because they
Okay,
were
sure,
multiple,
yeah.
was a situation where they were so scared of the school, they couldn't walk out their front door.
And we heard from a student last week whose family had to move.
Yeah. We've definitely had families move, for
Yeah.
sure.
Yeah.
And we do have a lot of them. So part of the work that I do as an education outreach is kind of hear all these stories so that I can then, like before they even come to the HRC to get a case, try to support them in other ways, negotiating with the schools to see if we can move them. And so there's a team of other organizations that support parents. Once the case, if there's a case that comes through, then I kind of remove myself. But we try to support some of these families to see, what can happen and so that they feel supported. In some of these districts, there's not enough BIPOC folks who can support and that can understand what is happening to the family. So it's really, still prevalent, and I do want to just encourage that when we need to look at the holistic picture of all the cases, and Rachel's an excellent resource.
You're so nice.
Well, I'm always with you, but because I think the attorneys kind of know like the cases a lot more, a lot of the prevalence. We have more of a view that we know that cases are increasing, and a lot of so when you look at the bullying and harassment data, also like we don't see all those cases that settle. That's not like what we see. So that data, when we're looking at it, I'm like, wait, I know these cases, but they got settled. So you're not seeing that. Nobody's seeing that. So the cases actually are higher than what we see in the data.
Thank you. Yeah, this is such a broad issue that isn't unique to schools. I mean, 3 of us are in health and welfare, and we're talking about folks in the healthcare system who, well, many of whom are not getting the care that they need, but also healthcare workers who are being assaulted. And so it's a really difficult moment in history, I think, just because they're just the way we're treating each other as human beings. And
We're seeing it in this building.
yeah.
Absolutely.
I want to say thank you to both of you. Rachel's already helped me in another issue before, so you are there for the folks who don't have a voice and who are often unheard, and it's really important work, and I just really can't thank you enough for what you do.
And it's an extreme, when an individual student and the family have to move,
Yes.
and we still have the problem because the only thing that changed is that individual student left. And we don't address the issue, the real problem.
The culture.
Right.
Yeah, there's a cultural shift that needs to happen, and I am really supportive of the schools and the educators. It's not easy, right? It's not
Right.
easy,
It's so hard.
and we don't have enough mental health support. We don't have enough special educators, so like we understand, but that we should always increase advocacy and ensure that if things are not working, that we shift systems. And like for me, creating the severe and pervasive piece around supporting, like students that might not have a case. Here's a personal story. When I was 16, moved to the US, didn't know English, was in a school, was bullied for about 3 months. And one day I lost it, and I got up. I was like, who are you talking to? I threw a stapler at the floor, and the teacher was like, oh my God, did you see a therapy? I was like, oh my, so, but that's what it was. It was like 3 months. And then when I was taken to the principal's office, one of the students came and was like, no, yeah, like the teacher never noticed that they were bullying her for I was sitting next to her, but nobody had done anything, right? So like those are the cases where we see a lot of this behavior, and then the person that has been bullied kind of loses it, and then because there was not that process in place to support them or feel seen. So I think it is very dear to my heart.
Absolutely.
And yeah, so this do
there's no
something.
consequences.
Yes, there's consequences. You gotta carry all of that with you. Thank goodness for therapy.
Right.
But yes, so this is just in a way to start the conversation about what is the holistic shift that we need to make and support our systems to be better for our kids.
Well, all right, so one last question, sorry,
Yeah.
Chair.
No, please go
Jump in.
for it.
Since we're talking about systems, what is the role of parents in like systemic change? Do you ever bring them in terms of, and trying to educate? Because we're all connected in
Yeah.
various ways.
I mean, she's your witness, so I want to give her a chance.
Oh, okay.
First.
Go
Okay.
ahead. You're my witness.
So the first thing I would say is that when it comes to students with disabilities, Vermont has, as every state is required to, a state special education advisory panel that is required to have a majority of the members be either people with disabilities or parents of students with disabilities. And I've been on that panel for the last several years. And for the first time, I think ever in the history of Vermont, our chair is now a parent of students with disabilities. So that is an important way for the agency and the board to be getting advisement on areas of unmet need for students with disabilities. And I can guarantee, I promise you, we've been talking a lot about restraint, seclusion, exclusionary discipline, harassment and bullying, the workforce shortage. Those are all topics that are on that agenda on a regular basis. And I think that our chair would be very happy to come in and talk about the work that we're doing and what we think you all could do to support that work. Parents have certain rights under the IDEA for participation, and they have the right to things like parent training and that sort of thing. And I think there is very much room to improve access to parent training and true incorporation of parent view into these processes, not just for IEPs, but when issues of bullying and harassment, when a student becomes dysregulated and they're subject to restraint, seclusion, and in terms of the exclusionary discipline process, the due process rights that have been established by the Supreme Court, which are what we have in Vermont, we haven't gone above that bar, are fairly minimal. And I think a lot of parents don't even realize when they're having their informal hearing before their student is suspended. So I think there's work that we could do to improve the parent role in many of these issues, and the inclusion of parents at the district level and at the school level.
And I think, so Act One, places a lot of view on the parents' role too, especially when it comes to like the education, it comes to curriculum for communities that might not have that many people of color or people from the LGBTQ community, so like supporting that work on it. And there's some really great examples of families who have gone through a bullying or harassment, who created then equity committees. So like, I think there are tools in there where some schools are doing great and have equity committees that have parents involved that do some education around the community processes. Some are not there yet. So I think there's hopefully, more work around that. There are things in place where, site councils where they can have the knowledge of the parents to support this.
Thank you.
Thank
Great seeing both of
Thank
you. And you'll email Hayden, we'll have you back.
I'll do that right now, Hayden.
Yeah.
And I will email you
Great.
the pervasive, severe and pervasive, in case you guys want to add it somewhere.
Yeah,
That would be great.
yeah. Maybe we'll actually, so tell us a little bit, what would you like us to add exactly? This is
So
the language change.
in the language on the harassment, and then it passed already on the House last year in the fair housing.
Oh, so it wasn't in an education bill?
No.
Okay.
no. But so we need to add it. We need to correct the standard in the education and the
Okay.
Public Accommodations Act,
Okay.
actually, which will include, education, schools. So that's how we add, and then we need to also add it in the fair employment. So like we're trying to correct all the three statutes that we.
Okay. We have our alleged counsel behind you. Ms. St. James, is this
Damian Leonard.
Damian Leonard? Okay.
Yes.
And, But it is education law that Damien would be edited, would be,
I haven't seen the bill.
Yeah.
Beth St. James, Office of Legislative Counsel, I haven't seen the bill recently. If memory serve, I don't know. I don't want to speak to that.
Sure.
But because we're dealing with public accommodations and the
Okay.
trickle down of that related to the hazing, harassment, and bullying policies, Damien is taking the lead on that.
okay, so there is something out there right now. And do we know where it is right now?
So the House has a bill now
Okay.
that was just introduced yesterday, got a number by Representative Coach. And I believe Senator Rump wanted to do something, but I have not seen it.
Okay.
So when I can,
When you see her, one option for us is always, if it's something, I don't know if it could go or should go into a miscellaneous education bill. But just know that that's a vehicle for us for the next couple of weeks. And I can touch base with Senator Rump also. I don't know if it just wouldn't mesh there for some reason, but we do have a
yes.
vehicle if it makes sense.
I would love that vehicle.
Okay.
And I will check
It's my
with her
favorite
and-
vehicle. You can
yeah,
add anything
yeah.
almost to it.
But yes, it will be changed to their public accommodations, which will include schools.
Okay.
So that's like,
So before we vote out the miscellaneous education bill, in fact, next week, why don't we have Ms. Garces in again? Just so we have the language, and we'll have Damien Leonard in with you also.
great.
And that would be an opportunity for us to amend accordingly. If again,
Perfect.
but he may come back and
Yeah.
say, hey, this really has to go in a different way. And,
Yeah.
Miscellaneous education, the thing about the miscellaneous education bill that I worry a little, if it's very serious policy, I want to make sure, not that things in miscellaneous that are not serious, but there are different levels of seriousness as
Yeah.
well. And I want to make sure it's the respect that it needs, and it may need to travel on its own.
That's
That's how I feel.
great. Thank you. And if I'm not here, my executive director will be here. Boria,
Oh, yes,
And she's,
great,
yeah.
yeah.
much more. A lawyer, but I'll also be a father with my kids.
Oh, you will? Oh, have a great time.
But I will make that happen. Thank you.
Thanks a
Thank
million.
you.
Good
Thank
to
you so
see you.
much for
Always
having
good to
us.
see you.
Thank you.
Thank you. Perfect. Good. Yeah, thank you.
You can stick around.
Thank you. While we're on this topic, we're looking at the school safety bill, and we're looking at a new version that we hope will leave us next week. And it does occur to me that, having heard from Ms. Garces, that we should make sure that, the Human Rights Campaign, the ACLU, others are kind of following and tracking this work, which Human Rights Commission, which they usually do on their own. But maybe we should just reach out to the ACLU in particular. Do we have your card?
Yes.
Okay.
I can get that to.
Just to make sure that everybody is on the same page as we move forward. Ms. St. James.
Good afternoon, Beth St. James, Office of Legislative Counsel. To just follow up on the conversation we were
Please.
just having, I found the bill you all were discussing related to the definition of severe and pervasive and harassment. It is H359.
Okay.
And
Where is it living right now, do you know?
it was just
It
introduced.
was just introduced.
Oh, well, let me tell you where it was referred. It was referred to general and housing.
Okay.
It does amend, and I think I looked at this language a long time ago. It does propose an amendment to the definition of harassment in Title 16
Okay.
to be consistent with that definition in other areas of the Vermont statutes.
And Title 16 is something we all know well. And so is that, in your opinion, something we could amend in a miscellaneous education bill saying that this is, or should it all be done to keep it all together, if you will?
It is certainly, it's amending Title 16 is certainly within your purview and
Yeah,
jurisdiction.
yeah.
How that is done, I think, is a policy decision.
Right.
Having piecemeal amendments
Doesn't feel great, but
there's nothing illegal about
sure,
that.
sure.
But that is a consideration.
Yeah. So if you'll talk to Senator Ron Hinsdale, and I'll try to talk to her, and maybe we see where the bill is. And it would make sense if you could touch base with the House Committee to make sure that they are going to move this soon, if it's a priority. If you end up feeling like you want that section that is our jurisdiction, Title 16 amended, for example, they may say, because it's late, crossover, I mean, I don't know if they're gonna take this up, in the next 2 weeks, 8 days, basically. If you can wait till next year, okay, but if you'd rather have it just amend 16, let us know.
Okay,
So we'll leave that with you.
great.
Is that okay?
Yep.
Okay. Great, okay. Thank you. Yes, and Dee Barbic, delighted you're here in the World Wide Web out there.
Thank you.
Yeah, great. So we are going through in, Ms. Barbic, do you have the most recent copy of the miscellaneous of the school safety bill?
Yes, I do.
Thank you.
Thank you. You should have draft 3.1 with today's date on it in front of you.
Bye-bye, ladies.
You all have. We're really looking at it, great. The changes between really draft 1.1, but also 2.1 and this draft are highlighted in yellow. I made one highlight in, I think it's debatable whether that's blue or green. It was blue on my computer screen. Just as there was a policy decision to be made there with the use of the word template, but the changes between yesterday and today are very minimal. I don't know if you want me to walk through them or you want to get right into the policy questions you left on the table.
I'd like you to walk this.
Sure. On page, so we're looking at section 1, amendment to section 1481, the fire emergency preparedness drills on page 2. In response to testimony you received, and because this is all new language, you're not going to see a strike through for the changes. You're just gonna, I get to delete it as I like. So each school district board that operates a school shall adopt a policy. That used to be the supervisory union. And I went ahead and made on line 3, I went ahead and added the S to drills based on the conversation yesterday about singular versus plural and what the singular excluded. And then we added the words at each school site. In the, oh, and there's in the, I didn't even catch that, in the little.
I'm sorry,
there.
where are you catching?
And on page 3.
Yeah.
In the fall, there's 2 in those.
So line 3, page
Yep.
2.
Yes. In the fall and spring of each academic year. So I'll obviously fix that. And then template was a policy decision on,
Right.
there was some
Back and forth.
back and forth on that. And then the sentence was added in issuing the guidance, the Vermont School Safety Center and the Vermont School Crisis Planning Team shall include trauma-informed best practices for implementing options-based drills. That language did not supplant anything. It was
Senator
all
Fuller.
addition.
Thank you, Chair. Up on line 2, sorry, I didn't have a chance to speak up at that point. Each school district board that operates a school, I'm just wondering if operates is the correct term there, and I'm sorry, because I know that you switched it from supervisory union, but school board operate the school.
I believe that I don't, so this is the base language here was drafted not by me. So I don't want to speak to the intent of the drafter, but the way I interpreted this is every school district, not every school district operates a school, right? Those are the sending districts. And so operates a school is a term is a phrase that we use to talk about. You could certainly say maintains a school. I think that's a commonly used term, but that to me, I read that as if you are not tuitioning your kids because you have a school.
Gotcha, okay, so it's not actually operating, that's sort of a term of art that's used in the law.
I think, are you asking or
Asking.
when you say operates, are you asking? Are you asking if it's a term of art related to this particular situation or in general?
In this situation or in the law? I'm only asking because I just have to laugh as someone who is on the school board. We constantly make the point that we're not operational. So I'm just.
So I think the so it's the school district that's operating the school, and the voters, I understand that there's the I understand that the administration of the school is doing the day-to-day operation. I believe that this is meant, again, to differentiate between a school district that has brick and mortar schools and that doesn't.
Yeah.
Again, you could use the word maintain. You could also, because it's the school district board that's adopting the policy and not the administration of the school that's adopting the policy, I think the saying school district board is important because they are the ones that are adopting the district-wide policy.
Absolutely, yeah.
So
Well, maybe the other experts weigh in on that, but to me, maybe maintains could be a better word there, but.
that's fine. I mean, legally, I think that's fine.
Other experts, what do you think is going to do it?
I don't know, like maybe like a superintendent or maybe Sue Sadlowski. Wonder what she would think of the word.
I mean, I've heard them both operates and maintains.
Okay.
So if you're more comfortable, I'm just looking around the room, is anybody pretty okay with, I mean, are you comfortable with maintains or would you just want to,
I'm comfortable.
you can think about it, whatever.
Yeah, I'm comfortable with whatever, because I'm not a lawyer, so if someone like Sue Sadlowski San Martin operates is the word that we use in this case, then I would be fine with it. I just, in my mind, I'm thinking it's funny that we always say we're not operational, and then I see the word operate, but I know it's not operate, it's not, I get it. So I'm flexible on that.
For what it's, so what we can do with this, of course, we will be doing is next week, we'll hear from everybody else.
Right.
Sue will be in again, and if she, we can just make sure that everybody's comfortable with operates.
Sure.
I'm fine either way.
I will just note that they,
Yeah.
in the feedback provided by the Vermont School Boards Association, the Superintendent's Association, the Principals Association, that wasn't a suggested change.
Okay.
So,
And we'll see them again, so we should just make sure that they're okay with it.
and then the next change occurs on page 3, line 15.
So before we get there, did we end up, and this might be dealing with it, did we, and Dee, I don't know if this is a question for you, are we all in agreement that independent schools are part of this conversation? Is that
Yes.
Okay.
Yes, sir, they are.
So the way that the discussion left off last time
Yeah.
was that was a TBD. So I haven't heard any direction otherwise.
Sure, no, that's
including
okay. So we have Pete Barbic right there, and I think what we were wondering was, we had thought that the Agency of Education, it was just an oversight that we're gonna treat the publics and the independents the same way as it relates to this. And Dee is shaking her head saying yes. So we wanna make sure that that is consistent with all of our schools.
Okay, so for on page 2,
Yeah.
the subsection B, there is already a section requiring approved and recognized independent schools to conduct the responses, the drills. I think the policy decision was whether or not they needed a policy.
And we want, and
Okay.
if the Agency of Education wants the same policy for everyone. And I see Dee is shaking her head yes, and I don't see any disagreement here. Thank you.
Section 2 on page 3, the next change is on line 15. And that is an addition of the word local in front of emergency management officials.
So Senator Williams' point.
Section 3 on page 3, line 20. So this is about access control and visitor management policy. And so again, this is a change based on the testimony from the V's. Each supervisory union, and then the new terms are member district board or supervisory district board shall adopt a policy. And it's all of them because the supervisory union district offices are also required to have policies, so it's all of them. That was the last change.
So the outstanding, again, this will maybe hopefully leave us next week. As you'll see next week's agenda, we are focused just on really what's on that board for the most part, save maybe one or two little things. Can we return to template? And would you remind us on page 2, line 5, the debate over that word? If you don't remember, I can.
Yes. The, there's no commentary, in the testimony from, the Bs on why they wanted that change, so I can't speak to it, but there was discussion yesterday about, there being a template and whether template was the right word to be used.
Does anybody have some thoughts on this? I mean, the reason I thought template was the right thing, but I could be wrong, was that if we would have consistency in every school, so if all of a sudden you got transferred to a different school or you took a new job, you'd have that. Dee, did you have your hand up?
I did, sir, if I could. So I think the words guidance and template are just reversed in this document, depending on what it's referring to. So in other words, the emergency operations plan, that is a template that's on the Vermont School Safety website. The drill guidance should be that guidance. So under the drill section, that like page 2, where we were just talking about, the policy, looking at line 4, the policy shall require that drills be conducted following guidance developed by. And so with the drills, it's guidance. With the emergency operations plan, it's a template.
And where do you see the emergency operation plan? Just so I
don't, somebody give me a minute to find that exact wording. Okay, so it's correct. So on page 3, line 16, shall maintain the Vermont School, and again, I'm going to connect with Secretary French once he has an opportunity to see this as well. But the on line 16, it currently reads, the Vermont School Crisis Planning Team shall maintain a template emergency operations plan. That's correct. So the emergency operations plan is a template. But going back to page 2 that we were just looking at, the drills are under a guidance, not a template.
And that's consistent with what the V's also had asked for. Yeah. Senator Weeks.
No, I agree.
Okay.
Yeah, okay. One question.
Yeah, I anticipated this. That's why I called on you. 2 seconds ago,
So on page 3, line 5, how routine is it for one arm of the government to find another arm of the government? And what's the net effect? Is this a routine?
Which branch of government is finding this branch?
So it says the school district on page 3, line 3, the school district independent school or educational institution whose administrative personnel neglect to comply with the provisions of the section shall be fined no more than $500. And the question is, that back and forth.
I guess I'm confused as to what, right, the legislature builds laws that fine all kinds of, builds in fines for all kinds of not following the law.
Okay.
Senator Sheen.
I mean, wouldn't it be the agency of education imposing a fine on a school district? Would that be?
That's what it is.
Yeah, so this is-
About independent schools.
This is current law.
Yeah.
Okay.
So without doing any research, I don't know how old it is,
Yeah.
or I agree that on its face, it doesn't say who's doing the collecting. But it's not uncommon for there to be a carrot or a stick when there are rules that are being required to follow, but this has been in law for some time.
Gotcha. Thank you.
No, okay. Ms. Barbic, any other comments or questions from you or anything else you were going to weigh in on? We're gonna have Ms. Simmons from the agency in next week, but I think the agency, from one email exchange, is feeling pretty good about the direction of things. I know you're gonna talk to Secretary French.
Yes, I'd like to connect with Secretary French so we can review this together. We haven't had a chance to actually connect one-on-one on this because I did have a couple of questions to run by him. But I believe we're scheduled to be in again next week for testimony as well. But yeah, I would just appreciate a chance to go over this with him directly.
Indeed, we may not have captured early on who you are and who you're working for. So if you would just state your name for the record and the organization that you represent.
Sure. My name is Dee Barbic, and I'm Director of Violence Prevention, and I work at the Governor's Office.
Great, thank you. Any other questions regarding this bill? So we will have a new copy. Yes, please.
Since we've got Rachel here from Legal Aid, do you think we could ask her?
Sure, yeah, sure, absolutely. It's a great idea.
So for the record again,
Yeah,
Rachel Seelig, Director of the Disability Law Project at Vermont Legal Aid. There's a lot in here that makes a lot of sense to us. The section that is actually of greatest concern to me is section 1485, section 4, which creates these behavioral threat assessment teams. We have significant concern that these will have a disproportionately bad effect on students with disabilities and overlap with what's already required by the IDEA, which is to do manifestation determination reviews if a student with a disability is potentially being excluded from school for more than 10 days because of a serious behavior. That process, unfortunately, we're seeing ignored in favor of an immediate removal and a requirement for a threat assessment as it currently stands. And this provision would take the responsibility from the IEP team, who is meant to develop the plan, create the supports for that student, away from the team that knows the child best and put it with people who potentially have never met the child, including law enforcement, which could very well criminalize disability-related behaviors. So this to me, this is why I came to sit with you all today, is because this is a concern for us. And what we've seen around the country when threat assessment teams have been created is exactly what I'm concerned about, which is that they have led to students with disabilities being even further excluded from school because of disability-related behaviors.
Thank you for this. Do you have a fix to it, or is it just a, I mean, do you have some language or something that you think, or is this?
From our view, the existing law, the manifestation determination review process, could be used before 10 days of exclusion. Right, so if there's a student who's exhibited a behavior that might otherwise go to a threat assessment team, what a district can already do or could be required to do at less than 10 days would be to do a manifestation determination review at that point, determine if it's a disability related behavior, and if it is, not exclude the student, but figure out how to amend the IEP and change the supports in order for that student to be safely accessing their free and appropriate public education.
Ms. Barbic, I don't know if you have any initial response. We will definitely, please tell me your last name again.
Seelig.
Seelig.
Yes.
Ms. Seelig?
Yes.
Ms. Seelig in next week, I think on Tuesday, so we can flesh this out a little bit more. And because I also just need to understand some of it and we'll have others weigh in on it. But I didn't know, Ms. Barbic, if this is something you want to weigh in on now or wait until we hear from Secretary of Education and more from Ms. Seelig.
Thank you, Mr. Chair. I would appreciate more time for next week's testimony, just so that I have a better understanding as well. And then also have a chance to chat with Secretary French. But yeah, I would appreciate to be able to listen to the testimony next week. And again, as I mentioned, just to get a better understanding.
Right. What I'm going to ask Ms. Seelig to do, if you would actually draft language.
Sure.
And send it to me, Ms. James, Ms. Barbic, as well, just so people have an opportunity to see it over the weekend.
Absolutely.
And then come and present, and feel free to copy the entire committee. And then we'll have an opportunity to look at it, and then we can jump into it a little bit more on Tuesday. But if you could actually think about your language as it relates to, this particular section, as where you would like it, et cetera. Sounds like, yes, please.
Chair, yeah, Ms. Barbic, I was just wondering in sort of on the other side of that equation, would it be possible for us to get some language and or data around the weaknesses of the manifestation determination review? Because it seems like there must have been a problem that was seen with that process to implement the behavioral threat assessment. No, am I not making sense? She's giving me.
I'm not quite sure I follow.
Okay, so it sounds like right now there is a process in place to identify potential threats that's called a manifestation determination review. So I'm assuming someone saw a weakness in that process to be suggesting a new plan called the behavioral threat assessment teams. And I'm wondering if we can hear more about that.
And let me start with Ms. Seelig. So there is, in your opinion, there's something that exists to assess threats like the one we're talking about right now?
Yes, in terms of students with disabilities, there is already a process in place. For students without disabilities, it's absolutely optional, right? That the MDR and the IDEA only apply to students with disabilities who qualify for an IEP. Section 504 provides some other protections before exclusionary discipline is imposed. And I think there's a tremendous overlap between behaviors that may very well lead to exclusionary discipline and some of the very serious behaviors that this bill, would propose to be able to prepare for and prevent.
Yeah, and so what I see, and this is just me thinking aloud here, we're trying to, assess behaviors that could threaten, of course, other students, faculty, staff.
Yes.
And you're saying right now, there is a process for that just for students with disabilities. So that strikes me as disturbing in itself.
Sure. Yep.
So
students with disabilities are also disproportionately subjected to exclusion.
Right.
Anyway, and are potentially more likely to be seen as students who may be a risk to their peers because of disability-related behaviors.
So how long has this been on the books?
At least since the most recent amendment to IDEA, which was in 2008, I believe, but maybe much longer. I mean, the IDEA has been the law of the land since the late 1960s.
So the manifestation determination review is out there on the books to determine whether or not students with disabilities are threatening or a threat to other students.
Whether students with disabilities behavior was a result of their disability. And that may very well be threatening behavior or behavior that might otherwise lead to them being excluded from school. So for example, maybe to make it a little more concrete, if a student with a disability says to a teacher, I'm going to bring a knife and I'm going to kill you, right? Like that's one of these serious behaviors. And that is a student who has a traumatic brain injury and therefore doesn't have that filter to be like, oh, I might think something, I have no intention of acting on it, but it's the verbal spew, right? If they have an IEP, what's going to happen is rather than going immediately to suspension or expulsion, if the plan would be to keep that student out of school for more than 10 days, or if they've already been suspended so many times that they may be hitting 10 days in the school year, their IEP team would be required to come together to conduct a manifestation determination review and say, is this a result of the disability? If no, then you can exclude them. You can do whatever you would do to a student without a disability. But if the answer is yes, then the team needs to say, okay, well, we're going to return them to their placement, their least restrictive environment placement. But what do we need to change in their IEP to address these behaviors so that this doesn't happen again, or if it might happen, like that we prevent it from getting to the place where it is a real threat. So that's what would happen to a student with a disability. the student doesn't have a disability, and they say, I'm gonna bring in a knife and I'm gonna, then it's very likely that they're gonna be facing exclusionary discipline because of that threat. And there may be other things that happen beyond just the exclusionary discipline because of that threat. And we've certainly seen that in our schools around Vermont and around the country, where it doesn't just impact that one student, but like the whole system of, making the building tighter or more, harder in order to keep people out or that sort of thing does kind of result. But this is the student-focused part of it that is already addressed through the MTR.
Yeah.
And I think one of the things that's important to understand is that this is not, in our view, something that is well implemented. So I recently worked with a student whose school kind of general administrators had never participated in an NBR before. And like, we're not familiar with the process. And so I think there's a training element for administrators as well in making sure this process works for students with disabilities. And I also don't think there's any reason to not have manifestation review for every student. Like, what's going on with the student? Why is this the behavior? Why do we think the student might be a threat? But with people who actually know them and who work with them, rather than strangers who are unfamiliar with them in the context of their lives.
St. James, do you have anything?
I do not have anything to add.
Okay. Thank you. Ms. Barbic, anything to add at this point? I think it seems like there should be a conversation between Ms. Seelig and the agency on.
I'm happy to reach out to the secretary.
Yeah, on what, what might be the best solution to what seems like
it's a tricky spot.
It's just a little bit of a tricky spot. Yeah, it's just a little bit of a tricky spot. But I see your point, and your point's a good one. And so, yeah, maybe what that language would be to make sure that we're all on the same page.
And if I could, Mr. Chair, I think that when we're looking at behavioral threat assessments, and we've heard testimony about the multidisciplinary team approach, and really, that's, I think, what's being mentioned here is really works hand in hand with the behavioral threat assessment approach, in the sense that if this were a student with a disability, with the multidisciplinary team doing the threat assessment, that would become, it seems to me, fairly immediately noticed and immediately known, and bringing that, the special educators or those that are involved in the IEP and such, bring them into that threat assessment because they have a knowledge of that student and their IEP if they have one. And so I think that's really, when we're looking at the multidisciplinary team approach, this is exactly why we're doing that. It's to bring all of these different perspectives in doing the threat assessment. And as was mentioned by Dr. Randazzo during her testimony, this behavioral threat assessment isn't intended to be a punitive tool. It's intended to identify behaviors and then resources that can be made available to that student to get them on a better pathway.
Rachel, would it help if part of the team had like a special educator, if there was a special educator on the team or a member of an IEP team? Would that be helpful, do you think?
I'd like to think about that a little bit more before I answer that question. Yeah.
Great. Okay, so we will look back forward to having you in on Tuesday with a solution. That would be a big help to us. Great, thank you. Perfect. Great, thank you. Okay, anything else, committee, before we move on? For Ms. St. James.
I'm not a part of the committee, but I do have a couple. I just want to say,
You are part of the
it sounds like you want to move this very soon. But there are other policy pieces in here that you have not discussed, as well as, or we haven't come to a decision on.
Okay.
As well as, yesterday we left off on some small non-policy edits
I apologize. I thought the only thing, I was looking for things in green. So yes, let's continue.
There's not, I didn't make these changes. We just didn't have time to talk about them
Great,
today.
great.
The School Boards Association.
And frankly, I mean, we have 2 weeks.
Okay.
We're not gonna move anything unless
Okay.
it's perfect.
Okay, I just want to make sure that if you want to go through all of the changes suggested, we haven't done that yet.
Let's keep going.
Are we on miscellaneous now, or?
No, we're on,
Safety. Okay, sorry.
In section 2, the emergency operations plan. The School Boards Association et al. Suggests that each supervisory union or supervisory district shall, instead of adopt, they'd like to see the word maintain. I don't have a thought either way on that.
well, if they have one, they would be maintaining it, but if they don't, they would certainly have to adopt one.
And
So we
perhaps
could-
adopt and maintain.
Or maintain, yeah.
They'd like to see language in all hazards emergency operations plan for each school site that is at least as comprehensive.
Line, the 12,
12.
emergency operation plan that is at least as comprehensive.
So they are suggesting, so the current language reads emergency operations plan, and they are suggesting right after plan to insert the words for each school site. So it would read, they shall adopt and maintain an all hazards emergency operations plan for each school site that is at least as, et cetera.
Ms. Barbic, I'm looking to you.
I don't think that would be an issue, but I would like to confer with Secretary French.
That'd be great. And we can hold on that one and have them come back to us on Tuesday.
And then there's a suggestion to strike after the word template on line 12. Going on to line 13, there's a suggestion to strike maintained and instead insert the word provided. I don't know
I mean,
if the template is being,
set our weeks.
Well, maybe Dee can comment on this, but I would imagine this is a living document that gets updated. So maintaining it in recognition of the crisis planning team might be appropriate.
I'm inclined to think so too.
It's going to change over time.
Right.
Threats change, new threats emerge.
And then therefore be maintained. Senator, Dee,
Yes, I think maintained, as you mentioned, it is a document that is subject to change, and I think there is even a section in this that requires that that document be reviewed annually. So yes, it is something that needs to be maintained. It's not, developed and then considered done forever. So I think maintain is an appropriate word.
let's stick with it.
and then there's a suggestion, staying on the same line, 13 on page 3, maintained by the Vermont School Crisis Planning Team.
I'm sorry, what line?
Line 13.
Yep.
Maintained by the Vermont School Crisis Planning Team is what the bill currently states.
Mhm.
And there is a suggestion to strike crisis planning team and replace it with safety center. And I don't know enough about, I don't know if that's,
I think they might, I'd say we stick with crisis planning team. I think they're thinking safety center. Perhaps they're getting confused. There is a Vermont Safety Center.
If I
Yes,
could, Mr.
Please.
Chair, I believe the safety center would be appropriate.
okay.
And then to go back on what we were talking about before, with the template provided or maintained, again, I would like to confer with Secretary French on that, just to ensure that we're in lockstep on that.
Yeah, we've agreed that you'll get back to us on that one also. Thank you, Dee.
And then they'd like, the last suggestion in this section is to add the word reviewed prior to updated. So if we're at the very end of line 13.
Reviewed and updated?
Correct. So if we're on line 13.
Yep.
The plan shall be reviewed and updated on
Makes
an annual
sense.
basis.
Thank you.
And then the last, there were, again, other outstanding policy questions, but on section 4, that takes us to page 4.
If I could
Please.
jump in for a second. I did want to point out on line 16 on page 3, the Vermont school, it currently reads crisis planning team shall maintain. That's, again, the same situation we looked at on line 13. It should read safety center,
Thank you.
not crisis planning team.
Thank you.
Again, on page 4, section 4, there is a suggestion on line 9. It currently reads, shall appoint a behavioral threat assessment team to be comprised of, and I know you're
Still debating some of
amending this
this. Yeah.
section, so I don't know if you want me to go into it, but there's a suggestion to strike all of the people the team would be comprised of. And replace it with following the guidance issued by the Vermont School Safety Center and the Vermont School Crisis Planning Team. And their note reads, with the requirement to follow guidance from Vermont School Safety Center and the Vermont School Crisis Planning Team, it is not necessary to spell out in law the precise composition of the behavioral threat assessment team. And I don't know enough about the School Safety Center or the School Crisis Planning Team to have a feeling either way.
Ms. Barber, do you mind checking in with the secretary on that one too?
Yes, I will.
Great, great. And we know Ms. Seeley is also going to be working on this section.
So those were the, that's the end of the technical changes that we didn't get to, or the language changes. We talked about each policy decision as it came up yesterday. I understand the committee's intent is to have the same requirements on approved independent schools.
Yes.
Is it, and also recognized independent schools, or just approved?
Can we do that? Because the recognized are,
You can do whatever you want, you're the legislature.
so recognized again,
Sarah?
these are, go ahead.
No, go ahead.
No, please.
Are you asking me what a recognized?
Yes, I'm asking, remind us of the
So a recognized independent school is a school, let me read the definition to you, but it's a private school in Vermont.
Yeah.
And they have to report to the, they have to be recognized by the State Board of Education. And they have some reporting requirements to the State Board of Education.
Oh, if they're already reporting things and things like that,
Yes.
then I would say, yes, if these is, then absolutely.
If the draft language only contemplates approved in some places and recognized in others, do you want to keep that?
I think we need to be consistent throughout and have recognized and approved all the way through. They're already reporting things to the state board, yeah.
And then it sounds like you're gonna have the agency in to talk about some of those larger policy questions, like what do they mean by educational institution?
Right.
And some of the other items we talked about.
So Hayden, the agency's coming in Tuesday, we're hoping?
Thursday,
Thursday.
Dean the secretary.
Okay, and what if, so on Tuesday, we'll have Ms. Seeley in.
Yep.
Yep.
And you will have spoken with Dee
Yes.
and the secretary. Could we have Dee come in on Tuesday also, just so the two of them, you know, when one comes in, we'll have the other come in as well. Okay, I think it's time for a new clean draft, and then we'll pick it up on Tuesday.
Yes, the changes again will be very minimal.
Absolutely. The ones that we've discussed, we'll see. Yeah. Anything else from committee members? It's kind of sausage making time. Ms. Barbic and Ms. Seelig, thank you so much for spending your time with us today and spending time together on Monday. And we'll look forward to seeing both of you on Tuesday.
Sounds good.
Great. Thank you.
Thank you.
Okay, great. Let's just take 3 minutes.